I'm Jamie Court. I'm president of Consumer Watchdog, and I'm here with Michael Klimusha, who's a ratepayer who's been overbilled by the DWP, and Lisa Tucker from Consumer Watchdog. And we're here today because tomorrow a judge is going to be asked, as of this moment, to approve a massive settlement regarding the Department of Water and Power's overbilling scandal. The Department of Water and Power in Los Angeles has overbilled customers tens of thousands of dollars. We're looking at 1.6 million customers in the whole system. And these massive overbills have affected a majority of the customers in the system. And so we are here today because the settlement that's been reached by the Department of Water and Power, unfortunately, will not help the ratepayers of this city get what they are owed. Scandal after scandal has ridden the Department of Water and Power. And today we've written to Mayor Garcetti and to Mike Feuer, the city attorney, to ask that this settlement be stopped and fixed before a judge is asked to approve it. This settlement gives the wrongdoer the right to determine how much they overcharged the ratepayers without any oversight or accountability. That is unheard of among class actions. When a corporation is caught doing something wrong, an independent oversight authority will be assigned to determine the cost of the damage and how much each consumer is owed. In this case, the Department of Water and Power, which was caught in an overbilling scandal, is going to be given the right to unilaterally determine how much consumers are owed. And what's worse, ratepayers won't be able to have access to their ratepayer information in their files to determine whether that amount is accurate. The only people who are going to be there to look at the dispute, if there is a dispute between a ratepayer and the DWP, is an industry consultant, utility consultant. And the special master on the case works for commercial customers, large commercial customers getting money back for being overbilled by large utilities. So if he sides with the large utilities, then we're looking at a situation where he's got a conflict of interest because they're not going to give him business in the future or deal with his clients in the future. We need disinterested parties to look out for the ratepayers, and this settlement is a sweetheart deal for consumers. This settlement is a sweetheart deal for DWP and a bad deal for consumers. And just to highlight some of the problems we have that we outlined in this letter, we're asking the mayor and the city attorney to look over the settlement before tomorrow and stop it. So in addition to the fact that the defendant gets to determine how much they owe the wronged, we're also seeing that in this settlement there's no third-party accountability and there's no transparency, and the settlement is silent on one of the most important parts of this case. Not only were people overbilled, they were also underbilled. And the DWP is issuing back bills for what was underpaid by ratepayers right now. Under this settlement, the consumers of this city are being asked to give up their right to sue before they know how much they're owed by DWP. It's wrong. But what's more, the ratepayers are also being asked to give up their right to sue and not know whether they actually may owe more because of a back bill. The settlement is silent on back bills. And what should happen with any back bill when a consumer has been underpaying for their services but not told, those back bills should be forgiven. But this settlement opens the door for ratepayers not only to not know how much they're getting in a refund, but be open to the possibility that they may get a big back bill later for underpaying on another part of their bill that would outweigh the refund. It is a sham. And these provisions need to be fixed, and the mayor and the city attorney need to fix them today if they want to continue their pro-consumer credentials. Make no mistake, this is a litmus test no longer for the DWP. This is a litmus test for the city attorney and the mayor as to whether they're going to stand up for ratepayers or they're going to let a black box at DWP determine whether consumers are underpaid and ripped off again. We have with us Michael, who's going to talk a little bit about his story. But before I do that, let me show you one other provision of this settlement, which is really troubling. How could this happen? Well, DWP says it's going to decide how much people get. But the one thing that's written in writing, because no one else knows how much they're going to get, is a Cleveland plaintiff's attorney who worked for 87 days on this case and is going to be awarded $13 million to control how other attorneys are paid. $13 million to a Cleveland attorney who worked 87 days on this case, and yet no other ratepayer in this city knows what amount they're going to get out of this settlement. The way Fortune 500 corporations settle class actions inappropriately is they find some beholden plaintiff's attorney who will settle real cheap for the people they're supposed to represent and walk away with a huge payout. And by giving this out-of-state attorney this huge pot of dough to distribute to the others in the case as he sees fit, or to keep for himself, they're giving him control over this case and the objections to it. And the reality is, by allowing the defendant to determine how much they're paying the wrongdoer and not having a check and balance on that, this is not going to make sure that ratepayers get what they deserve. This is why it happened. And this is not what a public utility should do. Maybe a Fortune 500 company can get away with buying off a plaintiff's attorney and giving too little to the customers. It shouldn't happen with a public utility, and ultimately Garcetti and Feuer are responsible for DWP, and they're responsible for looking into why this one out-of-state attorney could get so much money and control over this pot of money in order to settle for what seems to be incredibly unreasonable terms. The president of the lead organization for trial attorneys in the state, Consumer Attorneys of California, said this was one of the worst settlements he's ever seen. And it is because of all the due process violations we just discussed, because consumers can't be guaranteed that they have an adequate system to get what they're owed. And there may even be these back bills that charge them more than they get back. But we don't know. This needs to be fixed. It's not too late. Tomorrow it could be. So I'm going to let Michael talk a little about his circumstance. And maybe we could put up one of the bills, Evan, just to show what the circumstance is. But I'll let Michael talk about his.
Please say your name.
Yeah.
And,
Spell your name.
Yeah. Spell it.
Michael Klemusha, ex-inhabitant of Madison Apartments, small studio on North Orange Drive in Western Hollywood, just next to Blue Chinese Theater. When I moved to this apartment in September 2013, I actually consulted very diligently with all the neighbors and the landlord how much the electric bills, utility bills would be. And what the people were saying unilaterally, that they do not exceed actually for small studio $50 per 2 months for a single bachelor like I am. And it was really true until in about a year, in August 2014, I suddenly got a bill for $400. So that was a bit of a surprise. The first thing, well, I felt actually not informed. I didn't know what to do. Defenseless, kind of unprotected. So normally, what you do, you go to the nearest office of the Department of Water and Power. I went over there, I spoken to the customer service, and they explained to me that they installed the new meters, actually, which are good ones. The old ones were bad ones. They were showing lower rates. The new ones showing higher rates, so naturally they're good ones. And in accordance with these meters, a year ago, in November and December, almost a year, half a year ago, I consumed, in effect, 8 times more electricity than it was billed to me. Well, my natural question was when the meters were installed. The meter was installed in March 2014. So it's 3 months past the period which was billed. Technically, still, I have a bunch of correspondence, about 100 pages now, with customer service of the department. They actually keep on adopting pretty progressively. So they're explaining a new horizons all the time, new technical peculiarities. So I'm getting profound myself now. But still, I cannot understand how can technically you measure consumption of electricity in the past period by the new devices. So it just doesn't really relate to physical reality of the world we're living in. But then there is another the plane of explanation which concerns estimations. So department estimates and reestimates all the time. and it estimates so complicated formulas that the natural question is, why do they have the meters, which should meter actually the actual consumption of electricity, and thus, eliminates the necessity for complex estimations. Every complexity surely bears an error inside, imminently. And it is a huge problem for a consumer. When you're getting the first bill for $400 and you try to find the truth, and in a couple months you get another bill for another period, for another $400 again. So it just, it's just really horrible how much time you spend personally. And when you're thinking about in the scale of the whole city, how many human hours people spend, it's just I think it's just the hundreds, thousands of human hours and nerves, and just a waste, such a huge waste of time for the whole city and for the whole economy. And still, yesterday I've got a new explanation, because actually I was keeping paying because I was afraid that I will be disconnected, or and when I've got a new disconnection notice a week ago, my residual of the disputed amount, I paid $600, which I really think are disputable, because there isn't any explanation still, whatever. And I'm paying my current bills, which I do not dispute. I moved to another apartment, by the way, just across the street, and I'm paying $50 for 2 months now again. So my consumption has not changed dramatically. But I cannot be guaranteed that in a month I will get a huge bill because new meters were installed in my new place. So in any case, just yesterday I've got a new explanation that the previous apartment which I lived at is a so-called golden medallion. This is probably a new term which I never heard before. Golden medallion means that this building has a higher electricity consumption than other buildings around, which again seems to me a pretty weak explanation, if explanation at all. In effect, as we mentioned today, misbill me once and shame on you. Misbill me once and this is shame on me. And actually, I think that the only way to deal with the situation is for customer to get united. Just a personal experience. I moved to LA 2 years ago. I moved from Russia. Actually, I escaped from Russia because when you start to argue with the government, there is no any way how you can prove yourself. There is no any way you can prove yourself. So United States were, since my student years, just an ideal of the way how justice can find this right way through all these mysterious ways of the social system and politics and economical interest and so on. So that's the only place on the earth when you can find the truth, which is not easily, but at least sometimes you have a chance. In the other parts of the world, it's almost impossible now. And what I see now, it's like a kind of sad revelation that how hard it is, and what is happening now over here in California. I mean, the cradle of democracy, and it just a surprise for me as for a newcomer. So I'm really going to go to the very end, whatever it costs, to find the truth. I might be wrong. I might be do not understanding what department is saying, but this is really, up to now, this is insult to the intelligence, really, what they're saying. So until they're, start to move like more transparently and naturally, I think the consumers shouldn't give up.
Do you trust DWP to be the person who says after the settlement didn't get it right?
Well, I have my doubts. I mean, what I'm reading now about the settlements, I just really do not think that this is a way to do this kind of things because it's so discriminating. It just really makes the whole class of the consumers unprotected. And like it's like in particular, it's a quasi serfdom. You cannot really do anything about your feudal, because it can finally just disconnect you. I'm thanking for department. Yesterday I've got a notice as well that they extend my $200 disputed amount for 4 installments, so I can pay $50 per month. But once again, this is a side of the point. It's not the point. This doesn't have an answer. I do not need extension. I need to understand how much I owe to department and have to pay it. So just, but that's unfortunately the diplomacy which department clearly stuck to now.
Thank you, Michael. Let me bring up Lisa Tucker, who's going to talk a bit about some of the other bills, and we're going to show them now. Evan, if you want to bring them up on the screen, about go through them with that, go through how this works. But one thing I want you to understand is, if the DWP couldn't get Michael's bill right yesterday, how's he going to get it right on Wednesday when the settlement's in place and DWP is going to be the one to decide, and there's no real place to dispute any disputes except the utility consultant who also works with utilities, who's not much more likely to get it right. That's the point, is that DWP up till this very day is using the threat of disconnection, is not in its customer service system being accountable to consumers. So how can we trust a department that looks a lot like some of the government agencies in Russia and works a lot like that to get it right through this settlement? There needs to be some outside accountability. Tomorrow the judge will make that decision. So Lisa, do you want to go through a couple of customers? We had hoped that some of these people would come today. It's hard to get off work, especially with people who are suffering under their utility bills. So.
Okay, so there are lots of different permutations of things that have happened to ratepayers. Something like 180,000 were never billed. Others, this lady lives in Sunland, and she was getting bills of roughly about $250 a month, which was reasonable, and then suddenly she got a bill for $700, and so she called the utility and she said, I need a payment plan. She paid $500, and she got a payment plan for the other $221. Well, no sooner had she negotiated this with customer relations than she suddenly got a bill for $2,300, and she said, what is this? And they said, well, you know, we never, these were all just estimates. The bills that you were getting over the last year, they were estimated, and actually it turns out we never read your meter. And so now we've come out and read your meter and you owe us $2,300. Well, the bottom line is that she has every single bill going back through 2014, and every single bill she paid, they were roughly $250, and all of the meters were read all along through 2014. So now she's in a pickle because she keeps getting, you know, these $2,000, $1,500 notices that she doesn't owe. And fortunately, her service has not been cut off yet, but there are other people who have had service cut off because she's being represented by attorneys in this class action lawsuit. So that is the kind of thing that's going on. We have, you know, underbilling, we have no billing, and then suddenly people get, you know, get whopped, and we have overbilling like this. And it's fictional because the meters were read and they claim they weren't.
And that's one of the big issues we have here, is that there is no advocate for ratepayers in this process, and in fact, the settlement is silent on this underbilling problem, on letting people out of these back bills that come a year later and say you owe $2,000. And yet, in order to get the settlement, you have to waive any claim against the Department of Water and Power on a back bill, on an underpayment, in order to get whatever refund, which amount you're not told about, before you have to waive your right to sue. So this is just, you know, by any standards of legal measure, just an outrageous settlement. And for the city attorney to sign off on this is political malpractice. For the mayor to let it go is, again, you know, something that betrays the interests of ratepayers. They have not been involved in this process, but we're at the end zone, man. The DWP is about to run into the end zone and walk away from this billing scandal and future billing scandals with a waiver of their rights. And the city has two ways to go. It could stand up for the citizens and the ratepayers, or it could say, we're relieved because we're not going to have to pay consumers what they're owed. This is not a Fortune 500 company that's accountable to its shareholders. It is a city and a city-owned public utility accountable to the citizens. And if Garcetti and Feuer don't stop and look at this real closely, this will come back to bite them, I guarantee you, and it will bite us all. So we're hoping they act today, because today, until today, there's been nothing but silence, and tomorrow a judge is going to be asked to review this. And sometimes judges have different standards than people who represent cities. And we're hoping, because we're not in that legal process, that the political process works for the people, and they do a little inventory before we go to the judge. Thank you. Any questions before we?
Good evening.
Michael, will you spell your name?
Yeah, we're gonna yours.
Oh, well, you should do your Jamie, Jamie Court. I'm president of Consumer Watchdog. Do you want to spell your name?
Yeah, surely. Michael Klimusha. Klimusha.
I'm glad you spelled it, because I
Jamie,
yes.
City Controller Ron Galperin and the City Administrator have basically described DWP as an unaccountable cabal, particularly with their reviews of DWP trusts being paid $4 million a year with no oversight, trust administrators running around with credit cards, hundreds of thousands of dollars in automobile balances being paid, basically living on their credit cards and banking their salary. And once again, we have a utility that is not being held accountable to the people. Do you see some kind of class action on behalf of your organization or of an attorney that's willing to take on DWP to not just open these books and show how bad things are, but bring this company to a stop, and in the hopes of getting this going again?
Well, I think one of the problems is this settlement relieves DWP broadly of liability for almost anything it's done to ratepayers in many years. And ratepayers don't know what they're getting for it. We haven't contemplated bringing a class action lawsuit, but I can tell you there were a bunch of class action lawsuits brought before the gentleman from Cleveland came into the scene and settled, 87 days later for what looks like a really terrible job for the terrible situation for the consumers, and then the right to control that $13 million in legal fees and give himself or others what he sees fit. The city really is acting more like a defendant in a lawsuit here rather than a shepherd of DWP, and I don't understand, frankly, how those two foundations could walk away again this year with a couple $1 million more after what we know about those foundations, and the city controller's powerless to stop them. Well, if I were mayor of the city, and I never want to be mayor of this city, I would ask the IRS how these not-for-profits could really be not-for-profits when they don't spend the money ratepayers give them, except on some lavish living for the people who run those not-for-profits. We are looking into whether the IRS should be taking action here. But the reality is we shouldn't have to run to the IRS. The mayor and the city attorney should be doing something about this. The problem, frankly, and I am a registered Democrat, is we have Democrats running the city that don't want to be tough on Democrats. And they don't really think too hard about corruption. DWP is corrupt. Its culture is corrupt. Its customer service is corrupt. And the manager who's been put into place to fix it by this mayor has done a terrible job. She stood with those not-for-profits initially before it looked like she was going to lose her job, then she backed away. DWP is it is a Soviet-like institution in many ways. It is a Russian governmental agency that's unaccountable. It is as close to the Soviet Union as we have in this city. And there's a guy who could tell you about it. And there's no one watching, and there's no one suing. If we find an opportunity, if we have a whistleblower from DWP, you bet we will. But it shouldn't be up to us. The city attorney, Mike Feuer, is a good man. I know him. He was good in Sacramento for the consumer. I don't know why he's silent. Eric Garcetti, I believe, cares about this city. I don't know why he's been silent, other than they've turned the job over to lower-level managers who said, it's going to be okay, don't worry. Well, it's not going to be okay when consumers get what they think is refunds and they turn out to be bills. That's perfectly possible under the scenario, and they won't have a right to sue again because they gave it up to get what they thought was a refund. That is outrageous.
How do you respond? The Cleveland attorney makes 2 points, Jamie.
Yeah.
Point number one is he says that settlement says that he shall be awarded.
Can you pull this up again, Evan, just so we can look at what's in the settlement?
The wording of it is amount not to exceed $13 million. Now he is saying he will only be able to take the amount that he can prove to the court are legitimate legal fees, not $13 million.
Okay, well, the way class action attorneys work, unfortunately, and we've tried to break up many class actions, is they take a third. They don't produce timesheets. We do. Most attorneys don't. A third of what they anticipate the settlement to be is $13 million. But it says Plaintiff Jones will make an application. This is the Cleveland attorney's plaintiff for the court for an award of attorneys not to exceed $13 million and reimbursement for expenses. And then, yes, he may have to distribute it to some of the other attorneys. But the point is, this settlement very plainly gives him the right, if a judge says yes, to get up to $13 million. And the standard in these cases is a contingency fee mechanism. meaning it doesn't matter how many hours you worked. It's what the value of the settlement is. And I will tell you this, he will make a petition for these fees before those checks are received and cashed. It's the anticipated value of the settlement. It is what the settlement is valued at on paper, not whether the DWP customers actually got this after you balance out how many cashed the checks and what was underpaid in back bills.
Again, to be clear, he's saying this is not a contingency agreement. This is based on legitimate legal costs that he can prove to the court.
Well, I hope he can prove to the court that he worked enough in 87 days to make $13 million. I don't know what he anticipates. All I know is what the document says. And I can tell you, I've been in class actions, and what's accepted by a court is a declaration that as a class action attorney, I'm usually entitled to a certain percentage of what I make. And yes, that could be amortized out at thousands of dollars an hour, but I'm worth it. And I've been paid it before. And if he can make the showing that it's reasonable for the market, which is a terribly skewed market, then he'll get the lion's share of that.
The second point he's making is he claims that he understands the software that caused the problem, that he had a successful agreement with a Cleveland utility, that he's uniquely qualified to identify how much each of the plaintiffs have lost and be able to uniquely help them to get what they deserve. Your response?
This isn't a software problem. If this were a software problem, when Michael called or other customers called, there'd be a human being that figured it out and didn't tell them, we're going to shut off your power if you don't pay. This is a people and culture problem at DWP. And that's exactly the problem. This settlement presumes all the fault is based on some computer software that went awry. The fault is on the human beings who are supposed to catch it early and deal with it humanely, and up till yesterday, we're telling people their power would be shut off if they didn't pay their arrears. This is a cultural problem from the top of this agency to the bottom. This settlement doesn't deal with that cultural problem, and it puts all the power in the very customer service agents who are telling people who walked in with $50,000 bills to fix leaked toilets. True story. Ratepayers walked in with $50,000 overpayments and were told your toilet's leaking. I mean, I don't know how they're training the DWP customer service people, but those are the people who are going to decide how much people are owed and deal with any disputes under this settlement. How can we trust DWP to do that? And you can't, from Cleveland, really understand the depth of the problem until you talk to ratepayers like Michael and businesses who've seen this unaccountable department, not just with billing, but with repairs on pipes, for too many years. I mean, DWP is old-style backroom politics like maybe that's how it works in Cleveland. But in Los Angeles, it's not supposed to work that way.
And what are you specifically calling on Mike Feuer to do?
We're asking Mike Feuer and Eric Garcetti to simply read our letter today, look at the objections that we raise, and fix the problems and settle this on good terms for the people of LA. They've turned a blind eye. Clearly, the DWP and the people handling this at the lower levels haven't been able to get it right. And we're just asking the mayor and the city attorney to do what's done in every other good class action settlement, which is have an independent third party determine what wrongdoers should pay to the wronged, and to make sure that if there's a dispute, there's no financial conflict of interest when the person's deciding the dispute. So I don't really care about the 13 million as long as I want to make sure that the 35 million or the 42 million get to people like Michael and aren't canceled out by some underpayment on a back bill for which they don't have a right to go to court in the future if they deal with this agreement. I mean, this is full of holes, and the legal work that's been done so far suggests that he shouldn't be in charge. And the reason this guy's in charge is because he was the one who was going to settle and not hold out for what was right. And if he's got this pot of 13 million to keep what he wants and distribute to other people, he's going to buy silence among the people who represent the other plaintiffs because they need to get paid. So, you know, the city attorney and the mayor can't let a settlement like this go in an agency that's been riddled with these types of problems without being culpable of themselves. They're going to make a decision. Is this really what they're going to stand for in the city that they run? Because when the next wave of wrongful bills are coming out and DWP's blaming the next computer system and customer service agents are telling people to fix their leaky toilets for tens of thousands in overpayment, it's the same people at those customer service lines. The mayor and the city attorney are going to have to answer for it.
Is there anybody on the line?
Anybody on the line? Let me open this up. See, anybody in the line want to ask a question? Thank you, Lisa. Hold on.
The participant lines are unmuted.
Anybody?
Hi, this is Sharon. You're at KPCC?
Yes, Sharon.
The attorney is saying that you guys have been manipulated and misinformed by trial lawyers who have a personal financial interest in obstructing the settlement. What's your response to that? What trial lawyers is he talking about?
Well, you should ask him, but we do know some of these other lawyers who are involved in this settlement who I don't think would settle on these terms. But his role in this is what he should answer for. How can he justify this settlement without independent outside oversight of these bills, and how in 87 days could he come into this case and be awarded this $13 million as a pot of money that he gets to control? Why is he resisting the type of reforms in this settlement that are necessary to make sure ratepayers have a voice and are actually consistent with every other settlement that's done in a class action case except for lousy ones? I can tell you that public entities are more accountable than corporations, not less, and good class action settlements with corporations would never be approved under these terms. So, we don't.
Who are these trial lawyers he's talking about?
I think he's talking about the other objectors to the case, who are led by Tim Blood and two other people who filed the case, maybe a year before he came on. And the way, I don't know if you were on the line earlier, Sharon, but what I said was, having been around class actions, and by the way, we are not involved in this case, the way class actions are settled by corporations and defendants that want to settle them quickly is they find the weakest link among the plaintiff's attorneys who have a lead plaintiff in a case, and they get them to settle for a song, even if the other class members and their attorneys object. And not only have other class members and their attorneys objected, and they're going to be heard before the judge tomorrow, but even the president of Consumer Attorneys of California, who's a disinterested party here, said he looked at the terms and they are completely, he said that it's probably the worst settlement he's ever seen, although I'm sure he's seen quite a few bad ones. But there's no question, if you talk to any legal expert on class action law, that exactly what we're pointing to in this letter are exactly the problems that legal scholars and judges and others have with the class action system. And to turn over all the power to DWP is a real shame, and I think if his best answer is not a substantive one, but to say this is an internal squabble, I think what exactly happened was he took power from people in this case who probably would have held out for more. But when you look at the agreement on its substance, which is what we're doing today, there's no excuse for it, and we should do that, and that's what we're asking Garcetti and Feuer to do today.
Thank you.
Any other questions on the line? Okay. Thank you. Thank you all. Thanks. But